All right. Good afternoon, everyone. It's really nice to see you. We've got a great turnout today, so it's really nice to see everyone. Good afternoon. My name is Sean Moman. I'm the chair of the ADR section for the Georgia Bar. And on behalf of the section, I'm pleased to welcome you to our first program of the year, Religious Dispute Resolution. We wasted no time to have a program for the year. Looking forward to it. And I do want to start off by saying that today's program is going to be slightly different from the ones that we've had in the past. Why, you ask? Well, research has shown that a person's faith or religion can inform how they approach a conflict and negotiations, including whether a person will mediate or negotiate in good faith. And so, fortunately for us today, we have quite a panel, including our moderator, Dr. Leanne Bombach, who will help us explore how faith informs the resolution of conflicts. And so I'll start off by introducing Dr. Bombach, and then Dr. Bombach will present her topic and introduce the panel as well. Uh, Hi, Leanne. And so Dr. Bombach is a senior fellow in Islamic law at the Center for the Study of Law and Religion at Emory University. Her scholarship focuses on the intersection of religious law and secular law, with a particular emphasis on Islamic law, and her research interests include faith-based dispute resolution and Islamic finance. Dr. Bombeck clerked for the late Honorable Sam J. Ervin III of the United States Court of Appeals for the Fourth Circuit. She's also worked in the Washington, D.C. office of Latham and Watkins and was an adjunct at UGA School of Law. Dr. Bombeck holds a Bachelor of Arts from Brown University, a Master of Theological Studies from Harvard Divinity School, a Juris Doctor from University of Georgia, where she was editor-in-chief of the Law Review, and a doctorate from Emory University. Dr. Bombeck, good to see you and everyone else, and I'll hand it over to you.
Well, thank you so much. I really appreciate it. As Sean mentioned, my name is Leanne Bamback, and on behalf of the Center for the Study of Law and Religion at Emory, we really appreciate the opportunity to put together this program for you today. I'm especially excited because I've managed to talk three really great lawyers who are both experts in and practitioners of religious dispute resolution into joining us today. Stephen Garner, who will talk about Christian conciliation, Aisha Yukiu on Muslim dispute resolution, and Professor Michael Broyd, who is deeply knowledgeable on Jewish rabbinic tribunals, but will be focusing primarily on policy issues today. And not to put Sean on the spot, but I do want to mention that besides being the current head of our ADR section, Sean is also the head of the Aga Khan International Conciliation and Arbitration Board, which is itself a religious dispute resolution forum serving the Ismaili community and a real model of how dispute resolution grounded in religious values can not only be really efficient and compatible with the US legal system, but also really enhance the lives of its members. So I'm going to open today by giving a brief overview and legal analysis of religious dispute resolution in general, and then I will introduce each speaker in turn who will give their presentation, and my aim is to have about 10 minutes at the end for questions and answers. So if you would, please put any questions you have in the chat, and we will get to as many of those as we can at the end of the program. So there is a saying that there is nothing new under the sun, and that is indeed the truth when it comes to religious dispute resolution, which is also sometimes called faith-based or faith-informed dispute resolution. This type of dispute resolution, which takes place outside the auspices of the state's official legal system and its court, and looks instead to religious values or religious law, has existed since ancient times and has been utilized here in the United States since well before it even was the United States. As you know, many of the earliest European colonists to these shores came seeking religious freedom, and their religious authorities often explicitly discouraged people from utilizing the secular court system. Litigation was seen as unchristian, a form of aggrandizement contrary to the best interests of the community. Throughout the history of our country, other religious groups have similarly encouraged or even required their members to use religious dispute resolution mechanisms. So while religious dispute resolution has existed here de facto since the 1600s, it wasn't until the earliest 20th century that federal and state legislatures began passing arbitration acts that paved the way for easy de jure recognition of arbitration agreements and awards in these forums. This raises two questions. First, what does the First Amendment have to say about US courts enforcing dispute resolution agreements and awards? And second, if disputants are so keen to avoid litigation and have their disputes heard in a religiously affiliated venue, how or why would such disputes end up in a US court anyway? On the constitutional question, courts have pretty uniformly held that enforcing religious forms of arbitration does not trigger any First Amendment concerns because of the very limited scope of review given the courts when it comes to arbitration. When a court looks to whether it should compel arbitration, it uses ordinary contract principles to interpret the arbitration agreement. That is, whether the parties have an enforceable agreement, and if so, whether the underlying dispute falls within the scope of that agreement. This means that courts can compel religious forms of arbitration without ever having to adjudicate prohibited religious questions. Likewise, in deciding whether or not to confirm an arbitral award, the scope of judicial review is limited, and courts will simply apply the same grounds to modify or set aside an arbitration award from a faith-based forum as they would from a secular forum. For example, if the award was procured through fraud, corruption, or duress, etc. So here again, there is no need for courts to get involved in prohibited religious questions or interpret religious law. So that deals with the establishment side of the First Amendment. When it comes to the free exercise side, the Supreme Court has said that the government is barred from singling out any particular religion, or even religion in general, for disparate treatment. In practice, this means that religious arbitration must be given the same respect as non-religious arbitration on free exercise grounds. As to the second point, how or why do such cases end up in our secular legal system? As you will hear from the other panelists, disputants generally turn to religious arbitration or mediation out of a sense of religious obligation and or because they seek a path highly focused on reconciliation whenever possible, in line with their religious values. As might be expected, because of these religious convictions, it is in fact pretty rare that religious dispute resolution processes need any type of intervention by the US civil court system. Most parties who engage in religious dispute resolution willingly submit to and abide by the decisions issued or reached within their faith-based forums. However, it does on occasion happen that a party refuses to comply either with the agreement to utilize a faith-based forum or to abide by its decision. What happens then? Let me illustrate with a hypothetical. Orthodox Jews believe that, according to Jewish law, a dispute between Jews must be heard in a Jewish court and not taken to a non-Jewish civil court. So whether it's a family or a multi-million-dollar business dispute, Orthodox Jews will go to a rabbinical tribunal known as a Beit Din. So let's say a rabbinic tribunal hears a business dispute and awards one party $1 million in compensation for breach of contract. If the other party fails to abide by the decision and refuses to pay the $1 million, what can the rabbinic tribunal do? It has no real power to enforce the award itself. In that case, the rabbinic tribunal will permit the first party to go to a secular U.S. court in order to confirm the award. In this situation, recourse to the secular court is not seen as a breach of Jewish law. It is simply, as a practical matter, the rabbinic tribunal using the state authority inherent in the U.S. court system as a tool to ensure the enforcement of the religious forum's arbitration decision and award. So with that brief overview, I am now going to turn the program over to our first presenter. Stephen Gardner is a Georgia trial lawyer based in Bremen, Georgia, who has worked as a mediator and Christian conciliator for 25 years. He is a member of the National Academy of Distinguished Neutrals and the Georgia Academy of Mediators and Arbitrators. He's the founder of Peace Like a River Mediation Services and leads the Peace Sowers team at Midway Church in Villa Rica, providing Christian conciliation and conflict coaching. He has also taught biblical conflict resolution courses in church around the state of Georgia, as well as to pastors in Cuba. Thank you, Stephen.
Thank you, Dr. Bombach, and thank you for the opportunity to share a little bit about Christian conciliation and also giving me the opportunity to learn a little bit more about other forms of faith-based alternative dispute resolution. My mediation company is called Peace Like a River Mediation Services, and this is kind of what we'd all like for our lives to be like. The rivers are very peaceful. This scene is actually from Nanilchik, Alaska, which coincidentally in Russian, they tell me, translates roughly to peaceful settlement by the river. I went on a mission trip there a few years ago. My wife still says it was a fishing trip, but it certainly was a beautiful example of what Peace Like a River can look like. Unfortunately, this is what we seem to experience in life much more frequently than the peaceful river. Things get a little choppy. We get into rapids. Sometimes we're thrown out. And so how do we handle the conflicts that inevitably come up in life? In 1999, I was fortunate enough to be introduced to the concept of peacemaking by a gentleman by the name of John Ross. And he gave me a copy of this book called The Peacemaker, written by Ken Sande, who's an attorney. And coincidentally, today is his birthday. And so I want to wish Ken a happy birthday. When I started reading his book and read the idea that every conflict was an opportunity to glorify God, it just really changed my perspective about conflict. And I was hooked. I'll tell you, from that moment forward, I started going to conferences that they put on about Christian conciliation, learned a lot about it. After I got back from my first one, I got an opportunity to exercise some of it in that there had been a conflict between two men in my church. My senior partner had been handling the litigation. I told him I would be glad to work in a support role. But when he had a stroke and the case had to go to trial, I had to try the case. These two men were in the same Sunday school class at my church. And that took place before my introduction to Peacemaker Ministries. And it was sometime after that that I had the opportunity to pull the gentleman that I did not represent aside and apologize to him and tell him there was a better way for this to have been handled. I just didn't know about it at the time. Please forgive me. So I had an opportunity to do a little homework there. We handle conflict in different ways. And Ken Sande in the book, The Peacemaker, and in his subsequent work in Relational Wisdom 360, talks about the slippery slope. And this diagram illustrates that pretty well. If you look over to the left side of the illustration there, you'll see the escape responses. the most, if you look at the upper right-hand corner of that escape response, you'll see denial. We just deny that there is a conflict and ignore it. And a lot of times that doesn't work very well for folks. The next step over from it is the flight response. People see that there is a conflict and they will leave. They'll leave a church, they'll leave a marriage, they'll leave a business partnership, they'll leave friendships. So flight is one of the escape responses. And the most extreme escape response is suicide, where somebody just removes themselves from the situation that they just can't handle very well. If you look over to the right side of the chart, you see the attack responses. At the top of it, you'll see assault. And at one point in history, we had trial by combat. That's how people resolved conflict. There's an interesting movie that was done a few years ago about the last duel in France that was trial by combat. Now we're a little more civilized, and most of our assaults take place more along the lines of verbal assaults. The next step over from that is litigation, where that we have the lawyers go in and verbally assault people. That's been what I did for many, many years and still do to some degree, but hopefully in a little more civil manner. And the most extreme on the right-hand side you see is murder, where you take out the other person that's involved in the conflict. So if you look at the extremes on both sides, you have death involved. The peacemaking responses are up on top of the slope there. If you look to the left-hand side of the peacemaking responses, you see overlook. If something is not a big deal, and a lot of times stuff is not a big deal, you can just simply overlook the offense. But if there are repeated offenses that take place, there may be a need for personal reconciliation with regard to personal matters. If there are material issues involved, there may be a need for negotiation. Those are responses that the individuals take on themselves. If they're unable to resolve it on themselves, oftentimes they'll bring in the assisted responses, which would be mediation, where someone comes in as a neutral third party and tries to help the people work through their conflict. If that doesn't work, oftentimes you'll have arbitration, where that a decision is made. A person acts as a judge to make a decision, or you may have a panel of arbitrators. And then the last one on the peacemaking responses is the accountability, where you may take it to the church and have the church resolve the matter. And so in Christian conciliation, how is that different from a secular process? We've seen some of that just looked at there on the diagram just a second ago. Christian conciliation deals with the assisted methods there. It's taught that if you have a conflict with somebody in Scripture, Christians are told if you have something against your brother, go to them and try and work it out on your own. But if you're unable to work it out on your own, take somebody along with you. And that's when you go into either some individual counseling or coaching that helps somebody along the way. And then you also, if that doesn't work, you can have a mediation where the neutral third party comes in and actually tries to work with both parties at the same time to try and work out a resolution of the matter. And if that doesn't work, it can go to arbitration. And arbitration, again, is where somebody makes the decision for you. Mediation is where the neutral third party tries to help the parties reach an agreement among themselves. Arbitration is where you tell them what they need, what they have to do in a situation. What are the motivating factors for using Christian conciliation? Dr. Bombach talked about some of these. First of all, we've got the scriptural basis. Christians are told to try and resolve their disputes and keep it out of the courts. There's the relational aspects of it, because sometimes it's not just a material issue that we're dealing with. We're dealing with people that have relationship, and they're going to have to deal with one another again. And so oftentimes it's helpful to have Christian conciliation deal with these relational issues, to deal with forgiveness and extending grace and accepting responsibility. There's the emotional side of it. Going to court is not a lot of fun. It's very emotionally draining. And even though a Christian conciliation can also be very emotional, it's not near as bad as going into the courtroom. From a legal standpoint, if there is a valid Christian conciliation clause, which we see oftentimes in Christian businesses, they may be required to go through the Christian conciliation process. There's the privacy aspect that if you're going through Christian conciliation, that's going to be confidential. There's not going to be press covering it and things like that. It also is a witness factor. You do not want to hurt your witness as a Christian going through the secular courts if you can avoid that. It's a growth opportunity through coaching and having those discussions with people that the courtroom setting doesn't allow for. There's the financial side. Going through litigation can be very expensive. There's the flexibility side of it with creative solutions, where that when you're working in a collaborative effort, your solutions are you're going to have a lot more options than you would in a courtroom setting. And then there's just the time side of it. The courts are terribly backed up. That's why ADR has become so much more popular in recent years. The types of disputes that can be resolved through Christian conciliation are innumerable. Just about any kind of dispute can be addressed. I've dealt with partnership buyout agreements in professional situations. I've dealt with family disputes. I've dealt with large estates. I've dealt with personal injury. In fact, I have one of those tomorrow that I'm going to be doing. So just about any kind of dispute can be dealt with through Christian conciliation. We have established at my church a peace sowers team, and we're still in the training process there. But what we're trying to do is to help our members to be able to learn Christian conciliation, to maintain peace, unity, and healthy relationships. We see far too often churches just torn apart by conflicts that take place, and they wind up in the courtroom setting, and ministries are destroyed and churches split, and it's just not a good way for Christians to behave. So what's the future? The future we see as educating the public as to the availability and advantages of Christian conciliation over going into the courtroom all the time. We want to expand Christian conciliation in churches, and we want to use values-based models outside. And ultimately, the golden rule is what it's all about. Whatever you want other people to do to you, do to them. And there's a version of the golden rule in just about every culture and major religion. And a corollary to that is the golden result, and that is people will usually treat us the way we want to treat them. Thank you.
Thank you so much, Stephen. We really appreciate that. Our next speaker, Aisha Yukiyu, is an attorney, mediator, and social entrepreneur who is vice president and senior talent director at Robert Half. More importantly for us, her passion for faith-based mediation has led her to launch the Muslim Center for Dispute Resolution, along with a board of experts, including fellow attorneys, licensed mediators, therapists, and Islamic law experts. Additionally, Aisha is actively involved with the U.S. Muslim community, working with, among others, nonprofits such as the Muslim Legal Fund of America, the North Texas Islamic Council, and the Muslim Community Center for Human Services. Thank you for joining us today, Aisha.
Thank you so much. I just wanted to start by actually thanking you and Sean Moman for organizing this educational event and inviting MCDR to participate. I do have some slides prepared and I'll share them shortly, but before I jump into that presentation, I wanted to take the first part of this to just explain some overall concepts related to Islamic law that people might not be aware of. And so I figured I'd start with a little bit of that foundational background. Essentially, Islamic law is the legal system of Islam that is based on the Quran, the Sunnah, and the Hadith. So these are the sets of principles that guide Muslims in their daily lives. The Quran is the Muslim holy book, which is considered the direct word of God by Muslims. And the Sunnah are the sayings and practices of Prophet Muhammad, peace be upon him, which are also known as Hadith. So I know some of these, the vocabulary might be new to some of you guys. So, if we reference them, I just wanted to, put that out there. There are a few other concepts, obviously starting off with the greeting that you'll hear from Muslims, and I know other, traditions like the Jewish tradition as well. We start with Assalamu alaikum. So the root word is salam. And salam means peace. And so we are essentially saying peace be upon you, in our day-to-day greetings. And so, peace building, peacekeeping is a very central tenet of our faith. And of course, the desire for a more conciliatory process when it comes to conflict resolution is often one of the main reasons that people turn to religious dispute resolution, which is what we've heard with Mr. Garner's presentation as well. In Islam, there are specific concepts that are related to mediation, one being called wasata, which is a process for resolving disputes using a neutral third party. It's based on the idea that compromise and forgiveness can preserve relationships. The other concept that I wanted to touch upon is the concept of sulh. It's S-U-L-H. It's an Arabic word that means to make peace or reconciliation. It can also refer to a traditional method of conflict resolution in Muslim communities that involves negotiation, mediation, as well as additional rituals. Sulh is based on principles of forgiveness, reconciliation, and honor. It's intended to create lasting resolution between parties in conflict. And the process of sulh, which is something that we have incorporated into MCDR's infrastructure, involves selecting respected mediators and reaching a settlement that honors both parties. Sulh can be used to settle property disputes, feuds within communities, as well as other conflicts. Our mosques and masjids here in the U.S., also have issues that come up. I've been invited by several communities to come in, and whether it's in the capacity of being an investigator or a mediator, and I think it's something that we highly encourage the community to be a part of. And I love the fact that you have Mr. Garner was talking about starting these groups at the church for peacemaking, and I think that that's a great example for other communities to set as well. Further, I wanted to touch a little bit about what we talk when we talk about the hadiths of the Prophet, right? The examples of what Prophet Muhammad has guided our community with. There are a couple that really come to mind that include the importance of treating others well, the value of nonviolence within the tradition, and the reward for peacemaking. So according to the Sunnah, the Prophet Muhammad, peace be upon him, said, anyone who goes to make peace between two persons, the angels of Allah send blessings upon him. And that leads me to MCDR on our website, which is mcdrglobal.com. You will see a quote there, which says, making peace justly between two parties is an act of charity. So with that, I will share my screen and get into the formal presentation. So give me one moment. So the Muslim Center for Dispute Resolution was founded just 2 years ago to bridge the gap within our community and to allow our community to access dispute resolution services for all. This came from an urgent need that we have in the community right now, especially as the Muslim American population is increasing and they are looking for spaces outside of the court system to mediate their disputes. What we have found based on our surveys of our community is the lack of accessible and affordable dispute resolution services in the community has resulted in increased conflicts and a need for urgent attention. To that end, there is actually a statistic that some data that I was looking at that has been put together by the Islamic Society of North America, ISPU. The divorce rates, for example, in the American Muslim community are rising. Although they're not higher than the divorce rates for the general public, this is just one alarming statistic that has come up in the post-COVID years. And ISPU is conducting research to understand the reasons for divorce and other types of familial conflicts. So, ultimately, without access to a reliable and efficient dispute resolution process, many members of our diverse community are facing unnecessary hardship and suffering. And so MCDR is kind of here to address those issues. So in terms of what our mission is to promote, facilitate, and provide cost-effective alternative dispute resolution services with certified professionals and a faith-inspired process that employs the highest standards of integrity and transparency. So when our board was sitting together and discussing, how we envisioned this organization to move forward, we spent a lot of time taking a look at what exists currently out there, for the Muslim American community and how MCDR can fill the gap that exists. I'll come in a future slide, I'll kind of go into more detail about the certified professionals that we work with, because I think that this is really something that distinguishes MCDR from other forms of mediation that you might find at your local mosque. So here we have our core values. Again, these are values that we found important to articulate to the community because a lot of what we're doing right now with MCDR is community education and building awareness. I think for a lot of immigrant communities that might be coming from other parts of the world to the US, they might not, for them, this is their first time here, right? And so they might think that, oh, I have to go to court. They might not realize that, yes, there is a better way to resolve their conflict. So our core values include being obviously independent and neutral. All mediations are confidential, multidisciplinary approach. This is something, again, a little bit new to MCDR that we're incorporating. So we don't want to just be looked at as, oh, there's another group of lawyers, trying to come into this conflict. We do bring in other disciplines and professions into our process. Non-judgmental, collegial, and innovative, because we do believe that innovation is a key to successful conflict resolution, because a lot of times, as you all know, when parties are in the thick of it, they can't take a step back and, look at the bigger picture and try to find ways to resolve their issues. The areas that we cover, similar to other dispute resolution, firms is our matrimonial and family law, which is probably the hottest area right now. Business and commercial, we recently just completed a mediation for a family business, actually. And so this is another area where people seek Muslim-based mediation, nonprofits and mosques, any sort of international disputes, labor and employment, as well as estate and elder disputes. So the next part of this presentation is going to outline kind of our process. We are very much I guess this is an innovative process. So I think a lot of times you think of mediation and you think of, okay, there's a mediator, there's two parties or maybe more than two parties, and you kind of go back and forth between the two parties to reach a result. We do that, but we're kind of doing a little bit more of a deep dive because MCDR is really seeking to address some of the root cause and oftentimes even systemic issues that you don't really consider when you're mediating between two parties, right? So obviously first, a party will initiate a case, pretty straightforward. Then we have a case manager that will essentially evaluate the case with the parties to provide an overview of what our process is and collect the relevant documents. Obviously, as I mentioned previously, education is such an important part of what we do right now, just to let the community know that this is what the process looks like. It also helps the parties build trust in the process going forward. We introduced our mediator, and then we put together something called a conflict resolution plan. This is a customized CRP plan that addresses any sort of underlying systemic root cause issues that may be present in the conflict. The reason that we do this is because historically, a conflict is a conflict. We've been seeing almost the same exact type of conflicts over, hundreds and thousands of years, right? At the end of the day, we're all human and we face the same type of issues. And sure, they might look a little bit different in 2025, but at the root cause, a lot of these issues are very similar to each other. And that's something that we like to educate the parties about so that they can kind of have a high level understanding of what they're going through. Then we incorporate subject matter experts, whether it's a therapist, whether it's an Islamic fiqh expert who is grounded and understands the Quran and Sunnah and can address some of the issues in that light. We bring them in for a SME report. And then all of that helps lead to the mediation process, which is still very much the same, where the parties essentially come to an agreement with each other. So we're not telling them how to reach an agreement. We're essentially guiding them through the mediation process using these additional tools. And so why MCDR? Again, we are kind of at the forefront of ADR within our communities right now. We recognize that the Muslim American community is very diverse. They speak multiple languages, also come from many different schools of thoughts. So our team of certified professionals is committed to culturally sensitive practices. Our foundational values also further that cause. And so our mission is essentially to cultivate harmony and fairness for all in what we do. Other areas that are of priority for us going into this year are going to be enhancing our accessibility. So reaching out to mosques nationwide, letting them know that we're here to support them, ensuring affordability, of course, very, very critical, especially in cases of family law and divorce. We're seeing a lot of outreach where, one of the parties, can't afford a lawyer, right? Or can't even afford going to mediation. So we are exploring how our mediators and subject matter experts can work with such parties to ensure that they don't have to go through the court process and they can resolve their disputes in a more cost-efficient manner. And then thirdly is excellence in services. And so this is something that I think, of course, everyone here, as attorneys, we're always called to excellence in what we do. And so here, when it comes to ADR, we also want to make sure that we utilize, our expertise, our empathy, and we're efficient in getting to the root issues of the dispute. And with that, this is our website, mcdrglobal.com. We invite you all to check us out, come to our website. If you are a mediator of the Muslim faith and you'd like to join our roster, there's an application there for that as well. And I thank you again so much for your time.
Great. Well, thank you so much for that, Aisha. We really appreciate it. Our final presenter, Michael J. Broyd, is a professor of law here at Emory University School of Law, the director of its SJD program, and Berman Projects Director at the Center for the Study of Law and Religion. He is also a core faculty member at Emory's TAMS Institute of Jewish Studies. He is the author of the leading book on religious arbitration in the United States, entitled Sharia Tribunals, Rabbinical Courts, and Christian Panels, Religious Arbitration in America and the West, as well as a dozen other books and hundreds of articles. He has served on many rabbinic tribunals and was a member and past director of the Beit Din of America, the largest Jewish law court in the country. Thank you so much for joining us. I know you're last. Please feel free to take the time that you need. I don't want you to feel shortchanged.
Thank you very much. It's a pleasure to be here. And thank you, Leanne, for inviting me and your wonderful introduction, most of which is a gross exaggeration, but it's a pleasure to present on the public policy of religious arbitration. I shared with you some slides which you can go over on your own. I'm not going to PowerPoint my way through these. It's too classroomy to do that. I'm going to speak about the problems and virtues of faith-based arbitration. The central questions presented in faith-based arbitration are the same questions presented in every situation in which you let parties make their own law. I open always, every time I present, with the real religion in America, which is football law. Football is the real religion in America. It's nice to be involved in a rabbinical court, but countless rabbinical court judges would quit their job to become a member of the football court if only they could. Tom Brady, the high priest of football, was accused of cheating in an incident called Deflategate, and he was found guilty of cheating by the god of football, the commissioner of football, who sentenced him to 4 suspended games. And he appealed to the Second Circuit. And the Second Circuit said, we affirm the decision of the god of football, the commissioner of football, because Tom Brady agreed that if there should be a dispute, he would participate in the dispute resolution process of football. And we affirm the rights of people to agree on a legal system that governs their own disputes. And that is a very accurate recitation right now of the public policy in America. If we went back 100 years, we would understand that that was not the policy in America. Justice Cardozo, in a very famous case, Meacham versus Jamestown Railroad, tells us that law is truth, and the parties can't contract for a different truth than the holy law of the state of New York, and arbitrations are a nullity because everybody needs to submit themselves to the law of New York. The Federal Arbitration Act of 1925 overturned Justice Cardozo's approach and recognized that most of law is contract, and parties should have the right to create whatever law governs them. And whatever law governs them isn't only New York law or Pennsylvania law, it can be French law. And not only can it be French law, it can be Jewish law or Islamic law or canon law or French law as interpreted by Italian judges only in Tahiti and only wearing bathing suits. Parties have the right to construct their own legal system. And we're not afraid, or we recognize that parties might agree to a crazy legal system, but so long as they agree to it, we don't see problems in letting people craft their own contractual rules, even if they agree to a religious legal system that's at tension with American law, whether it be Islamic law or Jewish law or canon law, each of which has areas of tension. So what are the real concerns that American law has with religious legal systems? One real concern is that religious arbitration is sometimes coercively pushed on people. And even though they appeared to agree to religious arbitration, they were approached at a moment of vulnerability and they did not really truthfully consent. This was, to use the American law term, a contract of adhesion. And that is a concern. The second concern is that religious arbitration can sometimes be abusive in ways that are hard to patrol against, since the secular community has a hard time understanding even the biases and nuances of religious arbitration. And the third objection really is that frequently religious law isn't really law, but it's what we would perceive to be a cultural bias, and we simply are uncomfortable enforcing these cultural biases. None of these objections are essentially thought of as persuasive. As Professor Bamback mentioned, American law has taken a hard line against discrimination against religion. In Good News Club versus Milford Central School, the Supreme Court adamantly insisted that when the government opens a resource to everybody, the everybody that it has to be open to includes religious communities, and the government cannot discriminate against religious arbitration if it permits general arbitration. Now, I need to be honest with you here. Of course, the federal government could repeal the Federal Arbitration Act and not allow any arbitration. But we understand that in the real world, that's ridiculous. We're hard pressed to imagine commerce in the United States occurring without arbitration. And in a legal system that permits arbitration, it has to permit religious arbitration. Secondly, religious arbitration does a better job of resolving disputes that are at their core religious, what Professor Michael Helfand famously called co-religionist commerce, is best resolved by religious tribunals that well understand what the parties are actually speaking about, whether it's the delivery of kosher food or the provision of any religious resource. Religious arbitration does a better job adjudicating disputes where the core of the dispute is co-religionist commerce. Every faith does business with the faithful, and determining if each side has done as it agreed to is best done by a religious tribunal. And indeed, sometimes secular tribunals really are constitutionally prohibited from getting involved, like in the delivery of a religious divorce. Secular courts have very limited power to actually work in core religious areas. And it's important to understand that if we exclude religious arbitration, it will turn out that there are a whole host of disputes that secular courts simply cannot resolve. And let me add, by the way, the ministerial exemption is making this even clearer. In a conflict between a religious institution and its clerical leadership, difficult as it is to imagine that religious leadership might ever fight with the institution that employs them, we all know in the real world such disputes abound. And the Supreme Court has told us that secular courts essentially may never get involved in ecclesiastical disputes between a faith and its minister, leaving this area devoid of any possibility of justice, absent a religious tribunal. And thus, religious arbitration has to take up the mantle of resolving disputes, whether it be between priests and their Catholic Church, or ministers and their Protestant church, and imams and their mosque, or rabbis and their synagogues. Since the secular courts cannot do this work, this is the only way that justice can be brought to an area of law where the secular courts cannot get involved. And let me add one other thing. The existence of religious arbitration with secular confirmation of religious arbitration tribunals helps encourage a healthy dialogue between religion and secular law. This dialogue which I've been involved in for many years, is helpful to the faithful and helpful to the secular universe. It forces religious arbitration tribunals to write decisions that are secularly understandable. It provides secular judges with an insight and understanding of what goes on in religious tribunals, and it encourages them to dive deeply to understand a religious mindset that might otherwise be foreign to them. And it encourages this healthy interaction that on a social level breaks down the high wall of separation between secular individuals and religious communities, and encourages discourse in which common problems are addressed. It's worth understanding that while there are some problems of the faithful that are unique to the faithful, most problems that the faithful confront, whether it be breach of contract or divorce, are not problems of the faithful, they're problems of life. And allowing the faithful to listen to how the secular resolve these disputes, and allowing the secular to listen to how the faithful resolve these disputes is healthy. Of course, secular society has to regulate to make sure that agreements of arbitration are voluntarily signed and are not coerced. And they need to make sure that these arbitrations are essentially limited to monetary matters and not tread on the unique police power of the state. Arbitrators don't tase people. They don't incarcerate people, and they don't order beatings. Third, they have to make sure that arbitrators follow procedural due process. But religious arbitration is at its core a choice of law idea. And a choice of law idea is healthy, worthwhile, and valuable in the United States. People should be allowed to choose the law of California. They should be allowed to choose the law of France. They should be allowed to default to the law of their home state, and they should be allowed to choose the law of their faith community. All of that builds a peaceful society in which everybody gets what they agreed to. I think religious arbitration is consistent with the public policy of the United States, so long as the parties knowingly agree to it by contract. Thank you once again to the organizers of this CLE. It's a wonderful topic organized by extraordinarily competent people. Thank you very much.
Thank you, Professor Boyd. Really appreciate it. I am not seeing a lot of questions in the chat. Is there some issue with the chat that you know of, Sean?
I know we have one question that I see.
Okay.
I can read it out for you if you like.
Yeah, if you would do
Sure.
that, that'd be great.
Okay, so the question that we have is, how do Christian and Islamic mediators or conciliators account for and, when appropriate, disclose specific theological interpretations that might shape the expected outcomes of various disputes, especially family and domestic disputes? The theological position of the mediators could possibly impact their neutrality.
Would one of the speakers like to take that on?
Yeah, sure. I can address it from MCDR's angle. So ultimately, when parties come to MCDR to resolve their dispute, they are coming because they also hold some level of theological belief, and they are looking for that theological guidance. Now, the way that we do it, and again, this is a different model because to your point, we don't think it's the mediator's place to maybe give them that faith-based, perspective. And so we incorporate the subject matter experts, SMEs, right? So we have, for example, we have an Islamic fiqh expert on our roster who is a professor at Harvard Law. She teaches Islamic family law at Harvard. And so, Dr. Havaguni is someone that we have looped in, when we feel like there is an element of Islamic principles or something that comes into dispute. So that's the first thing. And then secondly, when we within the Islamic tradition, there's multiple schools of thoughts. There's obviously Sunni Islam, there's Shia Islam, and within Sunni and Shia, there's multiple different schools of thoughts. And so our approach is kind of a bottom-up approach where we're like, okay, if you're parties from a specific, school of thought within the Muslim faith, you can bring your SME, you can bring your imam or someone into our process. So we would still be kind of, we still organize the process of how the mediation runs, but they are allowed to bring in their personal imam or religious leader into the process to help us reach a solution. So that's been our approach.
Great, thank you. I see another really great question here. Are there resources for the reporting of decisions by religious tribunals or proceedings? Curious if there is something like the Federal Reporter or United States Reports that disseminates the outcomes of disputes.
Can I take a crack at this?
Yeah, go ahead.
Rabbinical tribunals regularly publish decisions, although there's no formal reporter. They publish them on their web pages in a variety of different ways, almost always anonymized, reflecting the fact that arbitration tribunals demand a heavy expectation of privacy. So they're not like federal reporters, which publish the names of the parties, but they publish abstracts of cases and the legal reasoning employed to resolve these cases. Absolutely.
Mr. Garner, do you know of anything in the Christian conciliation community that is similar to that has any kinds of decisions that are published?
I am not aware of anything like that, but that was one of the things that I was looking forward to hearing how other people did it. That probably wouldn't be a bad idea as long as the confidentiality provisions are protected in the process. And I think that, the rationale and law applied and scripture applied would all be very useful in future situations. So that's something I'd be interested in looking into.
Right. Sean, how are we doing for time? Do we have time for anything else?
I think we have time for one more question, and then we're just a couple minutes from the end of our program. And let me go and read this question for you,
Okay.
Leanne. Must one be a rabbi to oversee a Beth Din hearing? How must one be trained to oversee a religious dispute in the different religious groups?
In the Jewish tradition, in theory, one need not. In practice, the overwhelming majority of people who are involved in rabbinical court decisions are rabbis, but it's not unusual. And I've sat on many panels that have experts. So it'll be a 3-judge panel, one of whom will be a subject matter expert who need not be a rabbi at all, and commonly are not, particularly in child custody matters. It's common to employ a child psychologist who need not be a rabbi and who frequently is not a rabbi.
Christian conciliation?
From a Christian conciliation standpoint, there are certifications that are available, and that certainly is preferable to have people that are highly trained and gone through a good bit of study to be involved in the Christian conciliation process. It's, again, as the professor was just sharing, it's not necessary, but it is advisable to have some training. And there's a lot of training available through the Relational Wisdom 360 website if people are interested in that.
And do we have time for Aisha to put in a quick word?
Absolutely.
Aisha, any particular trainings that are required in Islam?
So traditionally people will go to the imam at the masjid for that. However, here in the US, at least I can speak for the Sunni Muslim, school of thought, there is not a certification process for a conflict resolution, certification or a mediator training. There are some imams that are getting that training, but it's really on a case-by-case basis, which is why we have MCDR, where we can bring the imams into a process that is run by certified mediators.
Super. Thank you so much. Thank you. So I think we are done. Sean, did you have anything else that you wanted to
Great.
add?
Yeah, no, I think this is great. I'm glad that we were able to put a panel like this together. So thank you, Leanne, Stephen, Michael, and Aisha for taking the time to be with us today and talk about at least the three different traditions and how they approach in resolving conflict, and whether it's mediation, conciliation, or even arbitration. So I think it was quite enlightening, and I hope everyone that has joined was able to learn from the experts today. I do want to take the last few seconds. I know we're a couple minutes over, and just plug the next two programs. Look, I said that we've just started in 2025, but we're not slowing down. We've got an amazing group, and we're going to be bringing two more programs. One is an in-person program next month, and it's going to be at the State Bar Office in Savannah. It's going to really focus on effective strategies and top tips in mediation and dispute resolution. So if you're interested in attending that event in Savannah, do look out for that information from the State Bar. And then the second session that we're going to have in February, which is going to be on the 18th, that's going to be a virtual lunch and learn, similar to what we're doing today. That's going to be on maximizing ADR opportunities, hot tips from the bench. And that's going to feature insights from judges who will share their top tips for leveraging alternative dispute resolution. So we've got great programs in store for you all today. Thank you for everyone joining today, and particularly thank you to our speakers and experts. And we look forward to seeing you in future events, and have a great day.
Have a
Thank you.
wonderful day.
Thank you.
Ladies and gentlemen, this does conclude today's meeting. Thank you for joining and have a great afternoon.